So, a warm welcome to this seminar on the Human Rights, Peace and Security Nexus in the Americas. My name is Ulrika Strand and I am Secretary General of the Swedish Foundation for Human Rights. Now, before I hand over to the moderator, Per Engström, who is a Senior Lecturer in Human Rights at University College in London, I would like to introduce our keynote speaker for this seminar. We're very honored to have Antonia Urrejola Noguera with us. Antonia is the newly elected president of the Inter-American Commission for Human Rights. Antonia is also the country rapporteur for 4 countries, Colombia, Ecuador, Guyana, and Nicaragua. She's also rapporteur for the rights of indigenous people and of memory, truth, and justice. Antonia was also principal advisor to the former Secretary General of the OAS between 2006 and 2011. On that note, Antonia, the floor is yours.
Well, thank you very much. Thank you very much to everybody, to the people that are in the panel. And also, first of all, I would like to thank the organizers of the Swedish Forum for Human Rights and the team of the Swedish Foundation for Human Rights for giving me the opportunity to share some thoughts on this relevant topic. The Inter-American human rights system explores the nexus between human rights and peace and justice, but I am certain that this link demands further and deeper reflections and conversations, especially in the pandemic and post-pandemic context. In this sense, I will briefly point out a couple of trends regarding the connection between human rights and peace and security in the context of the Americas, and from the perspective of the international mandate conferred to the Inter-American Commission on Human Rights. The first idea is that this nexus is connatural and traceable back to the origins of the Organization of American States and before. If we take a dive into the international conference's records prior to the adoption of the OAS Charter, we will note that these two notions are present in the debate and the discussions held by member states at the time. Given the post-war momentum at the time, it is almost self-evident why the topic of peace and security was a prime concern for the international community. However, what is so distinctive and unique of the process of the OAS is a special position granted to human rights ideals and duties, which led soon after to the creation of the Inter-American Commission on Human Rights. From that point on and up to present date, even though policies regarding peace and security are still part of the reserved domain of the states, they are not exempt from examination by the OAS and by the Inter-American Commission on Human Rights. This last point was critical during the analysis of grave human rights violations that occurred over the period of Latin American dictatorships in countries like Argentina, Brazil, Chile, Uruguay, and Paraguay, or the domestic armed conflicts in Colombia, Guatemala, El Salvador, Nicaragua, and Peru, just to name some. In all these cases, the Commission and later on the Inter-American Court asserted that the states carried out doctrines of national security, like for example Plan Condor, or means of combat implemented by security agents to defeat the enemy, in blunt opposition of the Inter-American human rights standards. The acknowledgement of these patterns have played a key role in the provision of justice for the victims of human rights violations and for truth and reconciliation processes still in the making of our region. As we have seen in the last 2 or 3 decades, how to consolidate democracy following the experience of violent repression and internal armed conflicts represent a continuing challenge in many countries of the region. Comparing the different peace processes, there is no doubt there is an intersection between democratization and war, or democratization and peace. Regarding, for example, the end of the Central American wars, much of the optimism that accompanied the signing of peace accords and the demobilization of guerrilla fighters after a few years dissipated. Building functioning democracies out of the ashes of dictatorships and conflicts has had a number of challenges. Peacekeeping cannot be effective without political willingness, without diplomacy, and without the participation of the different actors of the country and the society, especially without the participation of victims and their families in the reconciliation process. The role of international organizations such as the United Nations, the Organization of American States, or the Inter-American Commission is crucial, but it is not enough. It is essential that national dialogues take place, and they must include victims and vulnerable groups, the people that generally do not have a voice. The exclusion of key actors tend to fuel the crisis or simply delay it for the future. National dialogues must conform to international human rights standards. Long-term peace building is the responsibility of local people, many of whom have been involved in the conflict or grave violations in different ways, some as victims or survivors, some as perpetrators. We need to understand these processes of local peace building from below and to learn what is and what is not effective. We need to root peace building within specific social historical contexts. Conflicts have a social history. They are not abstract categories. The particular character of each conflict and human rights crisis have a profound impact on their societies. Men and women change their roles. They may be victims of terrible things, but they also have to cope with the situation. The role of women in these processes are essential. Their leadership has been crucial. Family survival usually comes to depend on women alone, but they also have a leadership at their local communities, and so they have to have a leadership in the process of peace building. They have to be protagonists. Peace accords, public policies, reparations, and remedies must have a gender focus. Also, the impacts of conflicts and human rights violations are unevenly spread upon vulnerable groups, such as Indigenous people, Afro descendants, children. This also must be taken into account. The debate about positive peace draws our attention to the apparently obvious that the absence of war does not necessarily mean the absence of violence in a society, and it certainly does not mean an end to conflict and the beginning of peace and security. Socioeconomic inequality, unequal gender relations, exclusion, discrimination, and racism are just some of the factors that fuel social and political violence in any society, and of course go against any policy of peace and security. A sustainable peace is only meaningful and possible if steps are made to deal with these fundamental problems. And these problems must be addressed from a human rights perspective. The issue of impunity, trust, justice, and reconciliation remains one of the most problematic issues in the aftermath of domestic conflict or political violence. The question of what is done to bring to justice perpetrators of extreme violence is no doubt at all the heart of peace. To finish my remarks, I must address the current situation of the pandemic for COVID-19. The Americas is the region of highest inequality on the planet. Profound social divisions characterize our region, where poverty and extreme poverty are deeply rooted problems that crisscross all countries, along with other related phenomena like poor access to drinking water and sanitation, food insecurity, environmental pollution, and the lack of adequate housing. Added to this, the high rates of informal jobs and meager incomes that adversely affect a large number of people in the region make socioeconomic impact of COVID-19 a heavy burden. All of this have prevented millions of people from taking basic measures to avoid the disease, especially people in vulnerable situations. Under this light, it is impossible not to know that the pandemic is both a problem of human rights and peace and international security. Concerted action focused on the realization and enjoyment of human rights is not only a roadmap to overcome the crisis, but also a way to understand security policies far from a military or defensive perspective. From the Commission's standpoint, we will continue working to reinforce this nexus, which is ultimately our mandate to defend human life. Thank you very much.
Antonia, thank you so much for that really comprehensive introduction to today's seminar. Thank you. On that, I will now hand over to Per, our moderator. Over to you.
Thank you to Antonia Urrejola, and I also like to thank Ulrika Strand for handing over the role of the moderator for this panel. So welcome to this virtual panel on the human rights and peace and security nexus in the Americas. I'm really looking forward to a great discussion because we have such great participants on this panel. The main focus of this panel is to look at the Inter-American human rights system and the OIS in terms of their contribution to objectives of sustaining peace and security in the Americas. And we're going to look at this from kind of institutional perspective on the Inter-American human rights system and the OIS, but also thinking about that link or those links between peace, security, and human rights from a historical perspective, but particularly focusing on the contemporary period. Now, we are very fortunate to have a great panel to discuss these issues with. We're going to start with Fredrik Svensson in a moment. Fredrik, as you know, is a program manager and advisor of international law at the Swedish Foundation for Human Rights, and he's going to, if you like, kind of set the scene for the discussion of the panel, and also, I believe, present some of the findings of a forthcoming report on human rights, peace and security nexus in the Americas. Then we have Jared Genser, who's joining us to talk about the role of the OIS, specifically in its efforts of peace and security and human rights promotion and pursuit in the Americas. Jared was recently appointed at the OIS by the General Secretary General as a special advisor and responsibility to protect. So he has great insights there in terms of the role of the OIS in developing this kind of set of norms and practices, of course, that drawing from the kind of global developments in this area over several decades now. Then we have Viviana Krsticevic, who is the executive director of the GIL, the Center for Justice and International Law, who has vast experience litigating before the Inter-American human rights system, and her organization, GIL, is, if I may say so, the most prominent organization using the Inter-American human rights system in its effort of pursuing kind of strategic litigation around a whole range of human rights issues in the Americas. And Viviana will provide a civil society perspective, if you like, on the role of the Inter-American human rights system and its efforts in contributing to peace and security. But also, I think, drawing in some other kind of lessons learned and perspectives on the kind of broader role of the OIS and the kind of political organs as well of the OIS in efforts of promoting human rights in the region. Then finally, we have Diego Rodriguez Pinzon from who's co-director of the Academy of Human Rights and Humanitarian Law at American University, Washington College of Law, possibly the law school in the US most responsible for the development of the Inter-American human rights system and the OIS in the sense of training various generations of lawyers, building, if you like, the rule of law, international rule of law in the region. Diego also has kind of broader experiences in the human rights field. He's current member of the UN Committee Against Torture and has also served as an ad hoc judge at the American Court in several instances. So great kind of range of experiences there to bring to our discussion. And Diego is going to kind of talk about the, if you like, an interaction here between local, regional, as well as in global levels in efforts of promoting human rights and peace and security in the Americas. And we'll also be touching on the interaction here between the Inter-American human rights system, the OIS, but also the UN, I believe. So the way we're going to run this, all things working well, is that our panelists are going to take 5 minutes or so initially to make some remarks, and then we're going to have time for a discussion and between the panelists in our remaining time. So without further ado, I hand over to Fredrik.
Thank you, Pat. Well, this seminar and the forthcoming report is the second step of a multi-year project with the objective of analyzing the human rights and peace and security nexus in the different regions of the world. The first region out was Africa. We are now finishing the Americas, and the next one will be Europe. Now, looking at the Americas, the Inter-American human rights system has historically played a role in relation to, for example, the military dictatorships of the Southern Cone and the internal armed conflicts in Central and South America, which has, among other results, contributed greatly to redress for human rights violations in these contexts, as well as to the development of transitional justice in the region and also globally. The Inter-American Commission on Human Rights has set up recently a special monitoring mechanisms for Nicaragua and for Venezuela, and they're also monitoring the implementation of the peace accords between FARC and the Colombian state, and has made visits and reports on these situations. When it comes to the Organization of American States, the OAS, it has been and it continue being involved in resolving the different conflicts and disputes of the hemisphere, including the demobilization of Colombian paramilitary forces for its own mission in Colombia, and the border dispute between Belize and Guatemala and others. Recently, the Secretary General has set up an office and a commissioner for the crisis of Venezuelan migrants and refugees, has also set up a panel of international independent experts to evaluate the possible crimes against humanity in Venezuela. And both of them have issued reports on Venezuela. And he has also appointed a special advisor on the responsibility to protect. Looking further, the OAS is also an important regional player because of its election observation missions to the region. This role leads me also to highlight another area intrinsically connected to human rights and peace and security, which became evident when researching the African region, namely democracy. Conflicts and human rights abuses are often on the rise before and after elections in Africa. And I think we could also conclude that the same goes for the Americas. We have some recent examples being the United States, Bolivia, Venezuela, and we have seen political unrest and power struggles in many other countries in the region, such as Honduras, Nicaragua, Peru, Chile, Guatemala, and Paraguay. Also, common to the two regions, the Americas and Africa, are some governments' actions to limit the powers of the regional human rights systems and the countries withdrawing from conventions and regional bodies. Now, one difference that we can see between the regions is the relatively high focus on women, peace and security within the African Union, while in the Americas, we so far at least interpret less regional interest in that agenda. We ask ourselves if it might have to do with a regional self-image as one that is almost free from armed conflicts. But it might also be resulting from a narrow interpretation of the women, peace and security agenda, and maybe considering being a UN thing, so to speak. Now, in the case of Africa and the African Union, we found that the rules of procedure of the African Union Peace and Security Council provide for cooperation with the African Commission on Human and People's Rights. And they stipulate regular meetings between these two. Unfortunately, that procedure had not been implemented. We also found that in the few cases that the African Union had tasked the Commission with conducting investigations on the situation of human rights in a specific country, the resulting reports were not duly used by the Peace and Security Council. During our research on the Americas so far, we find a similar picture, I would say, of little interaction between the regional human rights system and other parts of the OAS. However, having that said, we would of course be delighted if we were proven wrong on this matter, as we believe that a close cooperation between the different parts of the OAS would benefit human rights and peace and security in the Americas. We think it's a matter of breaking silos and of using available resources and expertise in an efficient manner. We believe that the current situation of conflicts, not only affecting national security and human rights, but also spilling over to the region, including Venezuela and Colombia, calls for such increased cooperation. Thank you.
Thank you, Fredrik, for that overview and for that introduction to the forthcoming report. You may want to add when the report actually will be made available. And
well, we hope to have the report ready by May this year. Okay,
right. So any kind of future listeners will be look forward to that after this being broadcast in that way. So this is, I think, a very helpful way of thinking comparatively across regions. So Fredrik very helpfully drew some kind of connections here with the African system, both in the context of the African Union, but also the African human rights system and the Inter-American human rights system. But of course, there's also a whole range of efforts here of thinking comparatively with Europe as well in this respect, and the European human rights system and the type of also the conflicts within the broader Council of Europe that are also being encountered, right? And I think there's also a very nice segue here to Jared, given that's perhaps arguably the place in the international kind of arena where the nexus between human rights, peace and security most clearly made is within this concept of responsibility to protect. And of course, there's another interesting comparison here between a concept that often is debated and kind of practically contested in contexts in Africa. And it's interesting to see efforts by the OAS in recent times of institutionalizing this concern for R2P within the OAS. So over to you, Jared, please.
Well, thank you very much, Par, for the introduction, and delighted to be here today. So I'm an international human rights lawyer based in Washington, and in October of 2020 was appointed by OAS Secretary General Luis Almagro to be the special advisor on the responsibility to protect. it may be kind of curious for people watching this to see the OAS appointing a special advisor on R2P, because R2P was adopted at the United Nations in 2005 at the World Summit, but has always, in fact, envisioned a key role for regional organizations to play in its implementation. And just to very quickly summarize, R2P has 3 pillars, as has been described. The first is that each state has a responsibility to protect populations from mass atrocities, including genocide, war crimes, crimes against humanity, and ethnic cleansing, let alone not be the author of such crimes. Number 2, the wider international community, which should include the OAS, has a responsibility to encourage and assist states in meeting their obligations under R2P. And then third, if a state is manifestly failing to protect its own populations from mass atrocities, the international community has to be prepared to take a timely and decisive response in accordance with the UN Charter, which could include up through and including Chapter 7 action of the UN Security Council. R2P was adopted because of the failures in the 1990s of the UN to prevent the genocides in Rwanda and Srebrenica, which both took place under the shadow of UN peacekeeping missions being actively in the country itself. And so what does this mean in practice for the OAS? In short, the OAS can't remain silent and become another international bystander to past and ongoing mass atrocities. And the reason why I was appointed is that Secretary General Almagro believes that if existing international mechanisms are not responding to the demands and the needs of victims of mass atrocities in the Americas, at the very least, the OAS should try to design and build a regional mechanism that can prevent and respond more efficiently and in a timely manner to crimes of this nature in the Western Hemisphere. It's also important to emphasize that this work builds upon the human rights work of the OAS through the Inter-American human rights system and the conflict prevention work of the OAS, but is actually distinct from those efforts because of the different legal framework that R2P has been developed through. The Inter-American human rights system exclusively applies the Inter-American or the American Convention on Human Rights and related Inter-American international legal obligations. Whereas R2P and the obligations of R2P were developed on the basis of existing obligations of states under major treaties, such as the Genocide Convention, the Geneva Convention, the Rome Statute, and the ICCPR. And I think it's important to understand and appreciate these distinctions because it is very, very important in my own work within the OAS system that I do work that is complementary to the work of others and not duplicative of the work of others. And so in my consultations with the Inter-American Commission and Court, for example, there was a common agreement among all of us that their work is quite different than mine, even if my work might draw on similar fact patterns, and we might be examining similar sets of facts in country situations. The legal instruments that we're applying and the reason why we're applying them is quite distinct and different. So what have I been doing in this role? First, in December of 2020, I published a major report with colleagues on the situation of crimes against humanity going on in Venezuela. This was about a 140-page report that not only described what was happening, but also and analyzed it as crimes against humanity, but also criticized the International Criminal Court for failing to open up an investigation into the situation of mass atrocities in Venezuela, despite having been considering it under a preliminary examination for almost 3 years. In addition, I'm engaging in wide consultations. I've spoken to 31 of 35 permanent representatives of the OAS, another 45 or 50 people within different parts of the OAS system, and about 20 or 30 civil society groups. All this is going to be towards developing what the next steps are going to be on our efforts overall. We'll be publishing a report in the next 2 months or so that will be based on all those consultations, what I'm recommending that the OAS do next to try to advance this kind of a system. And I know my time is limited, so I'm more than happy to answer further questions about what I believe will and should come next, coming from all of those consultations. consultations during the question and answer period, but let me just leave it at that for now, and just say that lastly, this is a pro bono role. I have a day job as a human rights lawyer, and so the OAS has very limited resources, and so I'm doing this work pro bono. And then I think it's also worth emphasizing as well that, that this is going to undoubtedly be a work in progress because of a lot of confusion about what R2P has meant in the Americas. And I want to emphasize that R2P is not about justifying the use of force or about regime change, as some have incorrectly thought. The biggest focus and the greatest attention that I'm going to be providing in this context is going to be really on prevention and early warning as a way to head off mass atrocities before, in fact, they begin to take root and to expand.
Well, thank you very much for that, Jared. Yet another very helpful overview of the role, but also how developments have taken place in recent period, really, over efforts of the OAS, and particularly the Secretary General of institutionalizing R2P. Of course, you've made a very important point here that historically some of these links, of course, between democracy, human rights, peace and security are kind of part of, if you like, the institutional DNA of the OAS in many ways, if you kind of go back over time, right? But it's interesting to see in recent years. And you made yet another promise, like Frederick, of seeing a forthcoming report on these matters. So we look forward to reading that. So the number of I think interesting points kind of raise once we get to discussion. One has to do with the kind of institutional relationships between the various parts of the OAS, Inter-American Human Rights System, that you mentioned. You refer to kind of complementarity, and also, of course, you raised the situation in Venezuela, which is on the minds of many once you start talking about peace, security, and human rights across the region. I'm sure we have time and to kind of come back to those points in a few moments. So thank you for that. So our next speaker is Viviana Krsticevic. Please, Viviana.
Well, thank you very much. It is truly an honor and a pleasure to be here, surrounded by all the new colleagues and friends. I was called to this panel to explore this very timely topic of the role of the Inter-American Human Rights System and the OAS in promoting peace and security in the Americas. And my work at CEGIL, at the Center for Justice and International Law, has been intertwined with these goals since the foundation of the organization. We work defending human rights victims before international courts, such as the Inter-American Court on Human Rights, and bringing issues to the Inter-American Commission on Human Rights and to the UN in order to pursue stronger democratic systems in the Americas and a better response for human rights victims and societies. And in doing so, one of the ongoing discussions has always been what's the role of human rights and human rights frameworks and international frameworks in pursuing democracy and in achieving peace and security. And for the purposes of this initial intervention, I just wanted to briefly bring to the table two complementary ideas focused on the role of the Inter-American Human Rights System in pursuing peace and security. And talking about the role of civil society in having a complementary activity to the Inter-American system to pursue those same goals. So the Inter-American Human Rights System, as it was developed by Frederick and also by President Urrejola, has made important contributions to human rights, peace, and security through the promotion of accountability for crimes against humanity, for a whole framework for pursuing justice and reparations, standards for dealing with violence and different types of threats under normal and exceptional circumstances, such as states of emergency, has developed responses on democratic crisis and erosion of democracy, support of human rights defenders and victims' rights, amongst many others. And my second point and an idea that I want to work in this brief presentation is that those achievements of the Inter-American human rights system were possible by this dialogue and interaction with human rights organizations and victims and civil society. In a nutshell, some of the contributions of the Inter-American human rights system are inspired, supported, and carried out hand in hand and in a dialogic process with civil society actors. So on the first point, I just want to highlight in a complementary manner to what was said before, that the Inter-American system has been critical in dealing with crimes against humanity by highlighting some of the critical situations that the hemisphere has had to face historically and currently, and by undermining some of the pillars of impunity and such as, for example, the use of amnesty laws or military justice systems or standards for the use of force or for due process that allow for prosecuting human rights defenders and victims and have shielded perpetrators of crimes against humanity. The Inter-American system has made incredible contributions on issues of gender equality and has made important contributions on issues of women, peace, and security. I think that has been a critical aspect of the developments of the jurisprudence and the actions of the Inter-American Commission and the Inter-American Court on Human Rights in calling on structural inequality, the use of rape as a tool of war, lack of accountability, and the case of Ginette Bedoya, who we just finished litigating in its oral stage before the Inter-American Court, is just one case in point. And also through the work, supporting the work of human rights defenders has also been a critical contribution of the Inter-American system to human rights, peace, and security in the region. However, there are many, I think, areas where the Commission and the Court, the human rights system, could do better, could do more, and I think that should be part of the discussion. I just want to highlight issues of how to respond from a human rights, with a human rights framework to the climate emergency, how to respond to some of the issues of democratic deficits and structural inequality, for example, as two of the main issues. And on the second point, and I think that because of the time constraints of our presentations, I just want to say that human rights institutions and international human rights institutions are inspired, their actions are triggered, and their mandates and orders and standards are even ultimately carried out by people on the ground. And in that, and in the Americas, human rights defenders and the human rights movement have been critical actors in ensuring that in different areas. For example, if you look at the development in the last 30 years on the framework of accountability and the development of the right to truth and the incompatibility of the amnesty laws with the American Convention, human rights organizations and victims were actually critical in pursuing those goals and ensuring after the decisions were made, these brilliant decisions by the Inter-American Commission and the Inter-American Court, they were the ones that then litigated the cases and did the advocacy and ensured that some of the work was done domestically and internationally to make sure that those things were had teeth on the ground and changed the realities of many of our countries, including Argentina and Peru and Guatemala and so many others. I think the same can be said with issues of equality. And I think the Belém do Pará Convention and some of the standards on structural inequality that the Inter-American system has developed have been critical tools to push for an emancipatory agenda and for an equality agenda on the ground for women and for many others. And I think that in the protection of human rights defenders, the community itself has been critical in the development of different tools and the workings of international fora to ensure that there is a civic space that is amenable for the enjoyment of fundamental rights. And that has been done, for example, and just to mention some of the examples from the last decades, pursuing a theory and a practice on interim measures, on precautionary measures and provisional measures that protects thousands of people in the hemisphere from risks and threats and allows them to work in the development of a rapporteurship on human rights defenders. That was one of the requests and one of the goals of many human rights organizations and human rights defenders, and we got that almost 20 years ago, and so many other issues. I think human rights defenders have been and continue to be an inspiration for the Inter-American system on human rights. I think of Francia Marquez, for example, in her claim on collective rights of Afro-descendant communities and the responsibilities of businesses as well as the state in the protection of rights, and Berta Cáceres, and so many others from Chile and Argentina to Canada that are an inspiration and are part of the heart, of the beating heart of the Inter-American human rights system. So that would be all for my initial remarks.
Thank you very much, Viviana, for those comments. It's a kind of nice kind of place to end your initial remarks here on that phrase, the beating heart of the OAS, looking at it from the kind of perspective here of various civil society organizations and also individuals, of course, who in the kind of daily lives and daily political struggles bring about change. So there are a number of things that I think are crucially important from what you're saying, Viviana, in terms of understanding the Inter-American human rights system, the OAS, if you like, more generally. So one has to do with the role of civil society here as a driver of change, right? That has historically been the case, as well as contemporary. And that, if like, kind of inverts in many ways our kind of perspective here on what to look at and look for in understanding change, institutional change. That includes, of course, organizations like Sahil bringing kind of advocacy and a whole range of kind of promotion activities, kind of bringing also voices to people and associations who might not as easily access organizations like the OAS. And the other important thing that I also believe will be part of kind of further discussions here is with regards to thinking about human rights frameworks as a way of approaching particular problem. So Jared mentioned a question here around crimes against humanity, and Viviana kind of made a very strong connection here that crimes against humanity and crimes against humanity as in the former international criminal law are not as distinct perhaps as they were previously understood to be. These are distinct bodies of law that have come together in very concrete ways by the Inter-American human rights system. And also that reminds us of thinking about human rights frameworks as an approach to conflict resolution, as well as kind of other existential problems that we're all facing, whether that has to do with the pandemic or indeed the climate emergency in many ways. So thanks for that, Viviana. And without further ado, kind of leaving Diego here, not on a limb, to make sure that you have all the time that you need. So please, Diego, over to you.
Thank you very much, Par. Thank you very much to all. And let me first just indicate that I must make a disclaimer. I'm speaking here as member of CAT, but as an independent in my personal academic capacity. So I always have to indicate this. I want to thank the kind invitation of the Swedish Foundation for Human Rights. I'm delighted, of course, to join this distinguished panel of speakers to discuss the matters that brings us today. Let me first say that I commend you for this exercise. We in the Academy on Human Rights, Humanitarian Law in American University have been doing several exercises similar to the ones that you are undertaking. We are doing it in the context of the master's degree in the LLM on Human Rights and also the advanced program of the Academy, and trying to bring to the discussions many of the actors of the Inter-American system, and again, from academics, practitioners, advocates, to tackle these very complex issues in our region. First of all, I want to briefly refer to a few aspects that are linked to peace and security in the Americas. And in this regard, it's important to mention first that the principle of non-intervention in domestic affairs has been especially important in our region. There is a great sensitivity among states of the OAS about any action that could imply a breach of sovereignty of states, either by other states or international collective action. This can be understood in the context of a hemisphere with an asymmetric relationship among OAS state parties and mainly with the United States. It is not a secret that there is a troublesome history of military interventions, such as those in Grenada, Panama, among many others. And this has enhanced the resistance among American states to any form of unilateral or collective intervention in a country of the region. This is why even the Charter of the Organization of American States was modified in 1985 to expressly indicate in Article 1 that the Organization of American States has no powers other than those expressly conferred upon it by this charter, none of whose provisions authorize it to intervene in matters that are within the internal jurisdiction of member states. And I'd like to cite that because, of course, language is crucial when we engage in these conversations on what is the potential for further action to confront mass atrocities, war crimes, crimes against humanity, so on and so forth. But it's very important to bear in mind this. This context may also explain how collective action to confront and prevent situations could threaten peace and security in the region, has mainly taken shape, among others, through robust human rights supervision of member states, especially regarding gross violations of human rights. The two human rights organs, the Inter-American Commission and Court on Human Rights, have dealt with many serious situations, but the Commission, as principal organ of the Charter, has developed broader powers to confront this type of situations. I can give some examples of the workings, mainly of the Commission. The first place, the Commission has, for example, worked through its Chapter 4 in the annual report, in which it includes a short list of states that are of particular concern in a particular year. Usually the concern is linked indeed to serious situations, and in some cases even mass atrocities. So there is a link there in the tools developed to single out those situations where there is particular concern through a long-standing practice of Chapter 4, complemented by the Chapter 5 of the Inter-American Commission that deals with follow-up to recommendations made by this organ to those states in the context of thematic or country reports. We can mention the on-site visits as a very important tool that the Commission has indeed developed to confront in a very practical and real-time approach these situations. And right now, I would say that it's now a very well-settled practice in the Inter-American human rights system. I can mention also the country reports, previously known as special reports. One of those, I think it's important to highlight, the third report on the situation of human rights in Colombia, that allowed the Commission to deal not only with state action conduct, but also with non-state actors, guerrilla groups, and assess their conduct in the context and application of the Geneva Convention, as it was mentioned before, of course, by Jared. Additionally, the Commission, in its case law, has resorted to, has dealt with context of armed conflict, the Abella case, that's emblematic in the application indirectly of the standards of the laws of war, in that case against Argentina, or the case of the Aizala, Ecuador versus Colombia interstate case, which again is an interesting individual case that deals with an international dispute, diplomatic impasse between two countries that could have very easily ended in an armed conflict. But I do believe that this case, among other efforts of the international community, contributed to de-escalate this situation. Viviana has mentioned, of course, the interim measures of the Inter-American system, both the provisional measures of the court and the precautionary measures of the Commission, which I do believe are quite important in reacting in real time to situations that mainly focus on the right to life and personal integrity. We are talking about gross violations, in many instances, in the context itself of systematic violations of human rights in those situations. Overall, these are only some examples on how the Inter-American system had an impact in very serious situations that could threaten peace and security in the region, either in that domestic or international level. One could say that the OEA's member states have allowed this expansive evolution of the powers of the Inter-American Commission as principal organ of the OEAs under the Charter, entrusted with a mandate to confront situations where serious human rights violations could occur or are occurring. Situations of gross and sometimes massive violations of human rights are usually intrinsically associated with peace and security. And in this manner, the OEA system has developed a way to strike a balance between the need to exercise collective action to confront this type of violations and carefully explore other modalities of action that should preserve the principle of non-intervention in the Americas. Let me also mention that other instruments of the OEAs are relevant to these efforts, such as the Democratic Charter and the political work of the Permanent Council and the General Assembly, as well as the OEA's Secretariat. Furthermore, there are clear synergies of the OEAs with other systems. For example, the UN Security Council, that is crucial for the preservation of peace and security in the world, has the monopoly, the use of force by states, with the exception of self-defense, of course. So that has to be part of the considerations and the broader context in this conversation that we are engaged now. Finally, let me just say that the Inter-American system could look and at relevant practice of other international regimes, just to mention the UN system and its Human Rights Council that has interesting references and practice in confronting many of these same type of situations when we are talking about, for example, the need to verify and collect evidence on specific situations on the ground. This the Human Rights Council has developed tools such as commissions of inquiry, something that again is very relevant when we are talking precisely about the collective responsibility to protect. The African system has interesting work with their working groups, collective working groups in the context of the Commission, allowing external experts to join an effort led by one of the commissioners to confront situations. That's something that also can give us some ideas for further development. The standards, of course, of the European human rights system are a very important reference for the work in cases and standard setting efforts of the Inter-American Commission and Court on Human Rights. I will leave it there, again, to looking forward to subsequent discussion among us all. Thank you very much.
Well, thank you very much, Diego, for that. Again, another rich set of issues that you raised here. Of course, one thing that is important to keep in mind when we talk about the OAS, or indeed kind of regional politics of the Americas, are historically the very strong set of norms surrounding non-intervention and indeed kind of associated to that the idea of self-determination, right? That has developed very, very strongly in response to what indeed is the kind of the historical fact of asymmetry and in a region, of course, that has a long historical experience of a whole range of different types of interventions. So that's an important, of course, kind of historical, but as well as kind of contemporary context to keep in mind whenever we talk about kind of collective action to promote any type of values, whether it's human rights, peace and security, or indeed democracy. And the other kind of important point, of course, that you're making amongst many, right, is the kind of the whole range of kind of different set of institutions that we need to take into account when talking about these issues, right? So it's a very and the many that we haven't mentioned, of course, today so far. We could, of course, think of Mercosur. We could talk about the UNASUR. We could talk about PROSUR potentially, and a whole range of different kind of constellations that are relevant when talking about peace and security, and indeed human rights and democracy across region, which is that kind of reminder to us that we are talking about a region that is very densely institutionalized, right? So many different actors, and this also reminds us, of course, about the kind of regional politics that we do need to keep in mind when discussing these issues. So I kind of like to start here and perhaps open up the kind of floor here for kind of further discussion, depending on how much time we still have available to us. But I think all of you have referred to this kind of political dimension of and also the relationship between the different parts of the OAS system. I think this is the term that Diego at least is using, OAS system, right? So we talk about the Inter-American Human Rights System on the one hand, which consists formally of the Commission and the Court, and these are autonomous organs of the OAS. And that, of course, is something that is really important to keep in mind. Yet they are, of course, under the auspices of the OAS and the various political organs of the OAS, and there are different views and different understandings of what the Inter-American Human Rights System can and should do with respect to a whole range of country situations. So my first kind of question, which is a broad one, which you can perhaps interpret you know, as you see fit for what you have already discussed, is what are the prospects for kind of deeper kind of cooperation amongst the various political organs of the OAS system, if you like, and particularly situations where there are, of course, very strong differences in terms of how to address the situation. Venezuela is particularly one case in point, right? But we also have a situation in Colombia, not simply in the kind of implementation of the peace agreement, but we saw recently, as Viviana already alluded to, in the case of Bedoya, the Colombian representatives walking out of a session and effectively challenging the authority of the judges of the Inter-American Court and sitting in judgment on Colombia. To my understanding, there has not been a political response of the OAS to that respect. Viviana might want to correct me in that respect, but my kind of question here for you to perhaps kind of develop on, you know, Jared, you mentioned, of course, the R2P as a kind of a set of tools, an emphasis on prevention, capacity building, not regime change, and legitimating use of force. But you alluded to the very, you know, present criticism of R2P to be exactly that, right? It's kind of a tool, if you like, of intervention, right? So how do you see those kind of political kind of conflicts over R2P within the OAS? And similarly, Viviana, you mentioned the kind of the heartbeat of the OAS being civil society organizations, but at the same time we see an OAS structure that often not just is inaccessible to civil society participation, concrete, genuine participation, right? But also, you know, political organs that put up very that prevents actively civil society participation in some cases, and Ginette Bedoya's case is a kind of some example of that in some respect, right? And similarly, Diego, you know, you kind of talked about this balance between, you know, kind of preservation of the non-intervention norm that's historically so important within the OAS on the one hand, and then, you know, the actual drive towards actually responding concretely to you know, either conflict or human rights situations in countries. You talk about this as being a balance, but is it really a balance, or is it a kind of an imbalance? You know, as when push comes to shove, the non-intervention norm, you know, prevails, and what can be done in that respect to kind of overcome the non-intervention norm is highly limited in the region. So a broad set of questions for each of you. So I turn over to you and to choose to pick up on any of those issues that I raised there. Jared, please.
Well, let me try to address the questions that you threw in my direction, although they're all very interesting, and make a couple of points, I think. In terms of R2P not being about regime change or the authorization of the use of force, I think one of the key things that I realized from the outset is going to be critical to my success and the OAS's success in implementing a regional system to advance R2P is education and awareness raising. And that's a large reason why I'm spending so much time engaging in consultations, because R2P itself specifically says in paragraph 139 of the World Summit Outcome document in 2005 that the intervention by the Security Council needs to be with the cooperation of the relevant regional organization. So there's no scenario in which there could be an appropriate or justified intervention by the Security Council in the name of R2P that was against the wishes of the OAS. And when you look at there have been only 2 examples in the first 16 years of R2P where there was the authorization of the use of force. The first was utterly non-controversial. It was Mali, where the government of Mali asked for help fighting and beating back terrorists that were, you know, terrorizing civilian populations, and was not controversial. And the second was in Syria. Sorry, not Syria. I'm sorry, apologies. In Libya, and the Libya intervention, of course, in 2011 was quite famous for what took place. And yet, people haven't focused, I think, a lot on the details of that. And when I say the details of that, what I mean is that the Libya intervention happened after the two relevant regional organizations, or most relevant regional organizations, the Arab League in particular, voted 22-2 to ask the Security Council to intervene with the use of force. And the GCC, the Gulf Cooperation Council, 6-0, or by consensus, also asked the Security Council to engage. And so while the intervention itself, it was indeed controversial because of the ultimate engagement in regime change, this was not against the wishes of the relevant regional organization. It was with the strong support of the relevant regional organizations. So I think education and awareness raising is going to be key. The reality is there's a strong non-intervention norm, as you were just mentioning, Par, in the region. And I don't see that changing anytime soon. And if the region remains committed to not being supportive of, the authorization of the use of force, then then I don't see any reason why there will be the authorization of the use of force in the region. But I'll just make one last comment on the non-intervention norm, which of course is very, very strong, as Diego was saying, especially given the history of unwelcomed interventions, especially from the north. One of the things I've discussed with lots and lots of people in my consultations has been that one needs to understand what non-intervention actually means, right? So to give you an example, Venezuela is a party to the Rome Statute. They signed and ratified the treaty. And when a country signs and ratifies a treaty, it gives license to the international community to intervene in accordance with the treaty, and whether it be in requiring regular reporting or whether it authorizing the jurisdiction in the case of the Rome Statute of the International Criminal Court to consider the situation in that country and to determine whether or not there are perpetrators that that may have been involved in the commission of mass atrocity crimes, etc. And so, in the case of Venezuela, you have a situation where both Juan Guaido and the government of Venezuela, that's recognized by the OAS, wants to see the ICC proceed to open an investigation and to investigate potential crimes against humanity. And you see Nicolas Maduro also calling for the ICC to investigate and potentially prosecute crimes against humanity. They're very different definitions of what those crimes are, of course. Maduro believing them to be the imposition of sanctions by the United States and other international actors. But is it an unwarranted intervention in the situation in Venezuela, or a violation of the non-intervention principle from the charter for the ICC to open an investigation and potentially indict people for crimes against humanity? And what I would say is absolutely not. This is not intervention. This is an international institution, the ICC, would be acting in full accordance with its powers granted to it because Venezuela voluntarily signed and ratified the treaty. So we have to be very, very clear when we say intervention. It doesn't, virtually all the countries in the region have signed and ratified the Genocide Conventions, Geneva Conventions, the Rome Statute, and the ICCPR. And trying to enforce international human rights law and norms and standards in accordance with such treaties is not an intervention in any respect whatsoever. And so we need to understand what we mean when we say intervention. And it's intervention that is extra legal or outside the context of the rule of law and in violation of international standards because a country has failed to provide license to the international community to examine a particular set of issues.
So I think that there's a very interesting discussion. I didn't want to get into it in my initial presentation, but now I feel a bit compelled to get into of what is the role of the Secretary General and the OAS in pursuing some of these crimes against humanity, and what is the role of the legitimacy of the OAS to do some of this work. And I do believe that the Inter-American Commission and the Inter-American Court are much better positioned to do a lot of what the Secretary General is trying to do right now. Because I think the perception of impartiality and fairness and due process is critical for some of these endeavors. And the Inter-American Commission has a better track record than most of the Secretary Generals in going and doing investigations, in-depth investigations on crimes against humanity, on governments of different political leanings in different contexts and situations. And it has lately further developed some of those tools to do an amazing job. For example, through, if you look at the group of independent experts on Ayotzinapa, for example, and or the group of independent experts and the different tools that the Commission used to tackle issues in Nicaragua. So when thinking about how to investigate and why and who, I mean, what countries, what issues, and how to go full force on crimes against humanity, which I think is a shared goal. I think the legitimacy and the fairness and the impartiality and the lack of a double agenda or a perceived double agenda should be critical for deciding who would be best positioned for that. And in that respect, I think that there are many things that can be done, but that should be thought through in a complementary manner, and taking into account the history of our region and the history of the OAS. And I am very concerned as a lawyer and as a human rights lawyer and as an advocate about the weaponization of law. I think there's a whole discussion in our region about how international institutions work, about how the judiciaries work, and on the right and on the left, this undermining of the rule of law and weaponizing the justice system, which is truly concerning, because it goes to undermining the credibility of one of the basic pillars of human rights, peace, and security, which is the rule of law. And I think that anything and everything that we can do from the OAS and from the Inter-American Commission and the Inter-American Court on Human Rights in keeping these legal processes insulated from some of the political processes, we will do a better contribution to human rights, peace, and security. Not to say that there's not a role for the politics of human rights, peace, and security, which is enormous, and there's a lot that the Secretary General and the OAS can do in a complementary manner. But I think that there are some things that should be insulated from others. And I think that the case of Ginette Bedoya is one such a case that it's very interesting to exemplify some of these dynamics. Why? Because if you look at what happened and what the government asked from the court, they said, well, we're recusing these judges, and now we want the permanent council to elect a new group of judges that are, more that are more palatable for us. So they were trying to, in a way, with and really a justification that had no legal or factual grounding, they were trying to politicize the whole process. And I think that that's very damaging. That's very damaging to and it's very telling. I remember Pedro Niquen, when Pedro Niquen was, for all of you that might not know him, used to be a very prominent Venezuelan jurist, an incredible, brilliant mind, and he was the president of the Inter-American Court at one time, but he remained very active in human rights and in the Inter-American system and in different types of discussions about these issues until the end of his life. And he used to say that giving some of these roles to the Permanent Council of ensuring compliance and impartiality and things like that were like giving the vultures, I'm not sure whether I'm pronouncing it right, that to take care of the meat, que los buitres cuiden de la carne. And I think that that has been indeed what has happened in many of the political spaces of the OAS. The OAS, in taking care of some of these human rights issues, has not been even handed in those political spaces because governments have not been truly the guarantors of the rights of human rights victims in the Americas. They have been very politicized in who they criticize and who they don't criticize based on political power and on the asymmetries of power and in the region. And that has been very troubling and problematic. And it is actually, I think, an anomaly that the Inter-American Commission and the Inter-American Court that are composed of people that are chosen by those governments are still really spaces that have and institutions that have been able to keep an even and fair and compassionate response to human rights and to some of the challenges of the region. And when I was talking about the role of civil society, I think the OAS has been increasingly, the OAS as an institution has been increasingly closing some of the spaces for meaningful participation of civil society. I don't see that as an opening trend. The last General Assemblies of the OAS have been really very, very difficult for human rights organizations and for civil society organizations in terms of participation. There has been a lot of, by governments from different ideological positions have agreed and concurred in trying to close the participation of human rights organizations and different types of organizations. So when I'm talking about the human rights movement and victims and civil society as being part of the beating heart of the OAS, and I'm talking actually specifically about the Inter-American human rights system. I think that system has been, I think, by virtue of their mandate, which is protecting human rights and having to listen to victims and seeing in very closely what's happening in the region, they've been much more permeable to listening and to responding according to what is their obligations of ensuring the defense of rights and justice. Not because they are very progressive or left-leaning, or no, because the evidence and the problems and is so strong that they have responded based on what are their own responsibilities. So okay, I'm sorry if I'm too vehement with.
No, thank you, Viviana, for those comments. Before handing over to Diego and Frederic as well, of course, I think Jared perhaps want to kind of respond to some of those kind of issues that were raised there. So just in a kind of interest here of discussion before going back to Diego and Frederic. So Jared, could you please short comment?
Sure. Just briefly. I mean, I think Viviana raises some very, very important and critical questions that need to be examined. And you know, I've had a discussion with the full commission in its entirety at one time, and a separate discussion with about a dozen of its senior staff. And I think that I'm not sure that I understand Viviana's perspective in terms of crimes against humanity and the jurisdiction of the commission, and we're both lawyers, so to speak more technically, the OAS charter says that the commission's jurisdiction is with what ultimately became the American Convention on Human Rights, or an Inter-American Human Rights Treaty. And the American Convention on Human Rights doesn't mention the words crimes against humanity, genocide, ethnic cleansing, or war crimes, not mentioned. Mass atrocities not mentioned in the American Convention. And so in my discussions with the commission and its staff, I was talking to them, for example, about the Nicaragua report that Viviana mentioned, which is a fabulous report. I mean, a really comprehensive view of what took place in Nicaragua in 2017, 2018. The title of the report, though, is called Gross Human Rights Violations in the Context of Social Protests in Nicaragua. Gross human rights violations has no definition under international law, and nowhere in their extraordinarily well done report do they mention mass atrocities, the word mass atrocities, genocide, war crimes, crimes against humanity, ethnic cleansing, and they don't talk about preventing what's happening, spiraling out of control into mass atrocities. And the commissioners themselves told me that in the recent context of forced migration from El Salvador, the commission staff had specifically asked them if they could do an analysis of what was going on as potential crimes against humanity. And the commission had a long debate and discussion about this and concluded the answer was no, because crimes against humanity as a legal concept are not within the jurisdiction of the commission itself. I just lastly note that for people who are afraid, and some people clearly are, of what I'm doing and how I'm doing it, again, my focus will be on prevention and early warning. And I've been asked, for example, what would you have done differently in Venezuela that hadn't been done if you'd been involved in this position in 2014? And I said that, to me, the early warning function is critical. And what I see in these kinds of situations as they develop is a siloing of information. And what I would have done back then would have been to put together a comprehensive report in 2014 on, the overall situation, not just human rights abuses, but the humanitarian situation, the political crisis, and the economic situation as objectively as possible, based on reputable, publicly consensus-based kind of sources, and then applied the UN's framework for atrocity prevention to that set of facts, which is a analytical tool published by the UN that looks at like 8 factors and 10 to 12 indicators underneath those to determine whether or not one can look at a situation as potentially evolving into a mass atrocity circumstance, and then made recommendations to the different parts of the OAS about what they may consider doing. And just the last 2 sentences here, if you look at the compendium of practice that's been published by the UN in terms of the application of R2P, and that compendium of practice covers the first dozen years of R2P, and it's hundreds of pages long. There are 40 or 50 examples of interventions that one could make, and interventions is not the right word, it's engagements under the R2P principle that one can make that have been made in the first dozen years of R2P. Only one of those 40 or 50 kinds of engagements would be the potential authorization of the use of force. And so I think we also have to be careful not to just conclude that R2P is just about use of force, when the compendium of practice and what's been going on globally on R2P has demonstrated unequivocally that it's really dramatically about early warning and prevention, which I think is something I hope we can all agree on.
Thank you, Jared, for that return. So over to Diego, please.
Thank you, Par. Thank you to my colleagues for the interventions. Very interesting. And well, simply I wanted to make an initial clarification. In my opinion, I think the scope of the application, for example, of the American Convention on Human Rights, it's quite broad. Article 29 of the American Convention not only indicates that it can be interpreted, but it must be interpreted in light of other obligations of the states of the Americas, which include, for example, the Geneva Conventions on the Law of Treaty, the armed conflict. It includes the Genocide Convention. It includes customary international law. It includes the Convention Against Torture. So indeed, we are talking about much of the same subject matter that, of course, has been interpreted extensively both by the Inter-American Commission and Court to indeed constitute a jurisdiction either in its case proceedings or in its reports. You can visit the reports of the Commission on many countries. It does apply and take into account UN conventions and a lot of the obligations of states, not only the positive wording in the region. So because it's a mandate of the convention, it's not simply the Commission or the court abrogating certain faculties, but Article 29, among others, very clearly indicates and calls the application, this extensive application that seeks to bring these other norms to the legal and political conversation in the Americas. But I don't think, and as you very well say, Jared, I don't think it's a matter of the use of military force or not use of military force by any means. The practice of R2P clearly is talking about a disaggregated set of tools that can be used by the international community to be able to confront genocide, ethnic cleansing, war crimes, crimes against humanity based on the 2005 resolution. And in this regard, when we bring these notions, I think, to the Inter-American human rights system, we have seen, based on what I mentioned initially, this tension that exists between the principle of non-intervention and the need to respond has taken this shape in the Inter-American system. A lot of the elements have been, in fact, developed by the Inter-American Commission on Human Rights, again, being a principal organ of the OES, sort of the Human Rights Council institution, with the benefit of being integrated by independent experts, which, as Viviana was saying, it's an important guarantee in the application of the instruments and the workings of the Commission. And in this sense, I think it's useful to disaggregate and look at some of the elements, the things that have to be done when we talk about R2P, when we talk about confronting this type of situations. For example, if we talk about sending an envoy or fact-finding missions by the system, you look at the practice of the Commission, has happened, is happening. Even in the case of Venezuela, the visit to the border, on-site visit, I mentioned the on-site powers of the Commission, and the fact of deploying itself to gather information in this way, initiating, for example, a mediation or conflict resolution processes. The Commission has indeed done, and not only recently, but even we're talking about the decade of the 80s. Many of you may remember the hostage situation of the Dominican Republic Embassy in Bogota, in Colombia. The Commission indeed had a role and deployed some of its commissioners to facilitate and, to a certain extent, serve as mediators in that particular setting that happily had a happy ending, in the sense that there was no loss of life and then there was a negotiated solution in that sense. I mentioned, of course, the robust human rights reporting. It talks by itself. Decades of reporting and monitoring by the Inter-American. It's an element of how to confront R2P. There may be some things that have not yet been implemented. There's room for improvement to further develop certain tools. For example, the issue of adoption of resolutions recommending specific actions to be undertaken. That aspect, I think, in the Inter-American system could, to a certain extent, take the shape of creation of a political space in the political bodies of the OES that will serve as enforcement of the decisions of the court and of the recommendations of the Inter-American Commission. We don't have that yet. Maybe the European Council of Ministers is an interesting reference, or another type of institution that will enforce many of these recommendations. Again, it's a complementary way in which we can envision this taking shape in the Inter-American system. A lot has been done by the Commission, and then you will build additional political mechanisms that will empower the application of these already very important contributions on displaced populations. I can give a long list of examples, and that's something that has not yet been done in the political level. So empowering those enforcement mechanisms would be very important for these regional human rights tools that do a lot in the realm of the responsibility to protect. Finally, I just teased a reference regarding the work of the Human Rights Council and what they have developed on commissions of inquiry or other mechanisms that the international community could develop to establish fact-finding operations that could preserve evidence even for prosecution in the future, international or national prosecution of war crimes, crimes against humanity, and others. That's something that allows for it could be further explored. I mentioned the commission could create a working group that deals with enforcement or some type of fact-finding missions. Viviana was mentioning this. There's already recent experience with the Mexico Ayotzinapa situation, Nicaragua, what has been done, these collective bodies of specialized experts that can help in prosecuting crimes against humanity and or war crimes in the national, and we don't know, in the international level. You mentioned, Jared, the fact that the International Criminal Court could be triggered in some situations. That's absolutely right, in my opinion. It doesn't threaten by any means that principle of non-intervention. And again, in practice, it means that in the regional system, we could in some way establish hybrid mechanisms, civil society experts with state experts, for example, to gather information and preserve it for some of the subsequent international efforts that could try to confront this violation. So a call to think creatively and complementarily. I think it's very important not to use this type of effort to circumvent a lot of the work that the human rights mechanisms have been doing, but to further develop those powers. I think the Inter-American system brings a lot of opportunity. There's a lot of challenges, but the opportunities are there in the sense that states are very willing to allow the Commission, for example, to develop many of these tools, which may not be the case in other regions of the world, among others, because there is resistance to anything that could get closer to military intervention. So think in those terms in order to develop these other tools, disaggregated tools to develop R2P in the system, taking into account that a lot has been done and is being done by the human rights system of the OAS. I will leave it there, Par. Thank you.
Thank you, Diego. Again, a number of important points raised there, and we're benefiting from the kind of insights here of three experts on the OAS and the Inter-American human rights system, but we also have here the perspective from, if like, the outside. I mean, I was struck by what Jared mentioned. I think some of his initial kind of comments here, and that is the very fact that we talk here about institutions that are laboring under very significant resource constraints, right? Whether that's in the Inter-American human rights system or indeed the OAS itself. If you look at the kind of budget levels here, they are fairly low in comparative terms to other organizations, regional organizations in the world. But also that kind of reminds us here of the role that external observers or external partners play in this. And the Swedish Foundation for Human Rights, of course, is one of those interested partners. And so will be hopefully the kind of listeners or viewers of this session. And that brings to kind of Frederick, and back to Frederick as a kind of representative of our hosts, right, today, in terms of bringing that comparative perspective, right? And I think what's so interesting in the work the Swedish Foundation for Human Rights doing here is to think about the OAS Inter-American human rights system comparatively, and you brought in some quite interesting comparisons with African system, for example. So, Frederick, do you want to come in with kind of additional comments or observations from where you're approaching the topic here today?
Thank you, Per. Maybe I will start there. We are looking at each region separately, but after we can already make some comparison between Africa and the Americas, and we hope to be doing a final comparison between all regions in the future. Now, maybe one first question is one that we see and have seen when we are making the research and contact people to talk about the subject, both in Africa and also in the Americas. And that is kind of the question mark. Where is the connection between the human rights systems, the regional ones, and peace and security. Because you can, I mean, the human rights systems are about state responsibility, right? And they are not about individual responsibility. But at the same time, as spelled out by Viviana, the regional system, in this case in the Americas, one of the results of the system in this respect is to bring states to issue, I mean, to do their duty as a state to prosecute and sanction those responsible. So in a second step, you will have that effect. Then that also brings us to kind of a missing piece here at the regional level, a possible piece, which is, I mean, it's foreseen in Africa, a regional African Court of Justice, which could also bring individual responsibility, although for, I mean, obvious political reasons, that court is yet not a reality, and it's quite hard to see it becoming a reality also in the Americas, of course. I mean, of the different reasons that we have seen in terms of state action in this area, and of maybe not cooperating that much with the system and not wanting to create additional mechanisms. And that also leads me to the kind of the international order and the responsibility to protect, where we see kind of the mandate from the UN Security Council, but it's also a bit contested in Africa by the African Union, and the African Union is a bit contested by the sub-regional intergovernmental organizations. And maybe that is, I mean, it's quite expected, I would say, because if you look at the membership, the composition of the UN Security Council, you don't find the countries in that council. So I think that is also a development that we might see more of in the future. Then I think what Gerard is talking about also when it comes to the responsibility to protect and the emphasis on early warning and prevention. We see that quite developed in Africa, where we have a 24/7 situation room, which is following the development throughout the continent. So maybe that is something that we could bring into the Americas somehow. Of course, also in terms of that, fact-finding missions, which could be made of experts from the Inter-American Commission for Human Rights. And that is kind of the what we are seeing also. We see that in Africa. I think we can see that in the Americas as well. Using the resources, the experts of the Inter-American system for human rights, also in other spaces of the OAS, could be fruitful. And as Viviana also was commenting, that it's also probably seen as more impartial some way, because and I mean, that's not any news for anyone. Politics is in human rights. Politics is in peace and security, like it or not. But it's a factor that we we need to take account of, even though maybe as human rights advocates, we would like to stick to the law. Let's see. And I think that strong component of monitoring and prevention that we see in Africa could be important also for the Americas. Another thing that is very talking somehow in Africa is, even though, I mean, both organizations have a background, a history of wanting to promote and sustain peace in the region. What you see in Africa is in the human rights conventions, you see it in the African Charter, and you see it also in the Maputo Protocol, is the right to peace, which is quite powerful when you talk about peace and security and human rights. I think I leave it there.
Thank you, Fredrik. So I'm conscious of the time because I know in DC there's, I'm sure there are things that are kind of demanding on your time over the course of the day. Over here in Europe, we have demands that come at the end of a kind of working day picking up. But I don't want to kind of leave it like that, and I do want to give you kind of the Jared, Viviana, and Diego kind of a chance to add to the discussion. I don't know how much time more we do have or you have available, but how about we can give it another couple of minutes each to kind of try to sum up your observations and perhaps respond to some of those comments that Fredrik made. And so, Jared, may we start with you?
Sure. Well, this I think has been a really helpful and useful discussion, and I have no doubt that I'm in vigorous agreement with Viviana and Diego on probably 99.9% of the things that we've been discussing. It's really a matter of form, because when one talks about these issues, because of course I fully agree with Diego, for example, that the Inter-American Commission is doing a lot of the things that are considered R2P interventions in various contexts. And of course, I'm not suggesting I would, my role, step in and try to substitute myself for their role. In fact, I made very clear to them that my work will be complementary to and not duplicative of their work. The role that I see myself playing is a narrow one, which is to, on behalf of the Secretary General of the OAS, try to facilitate the cross organ and agency work that needs to be done to have a more robust collective set of responses in these kinds of circumstances. Again, I made very clear to the Commission that I'm not going to be stepping in and trying to do their job in any way whatsoever. But I do think that when you look at the situation in Venezuela and you look at the kinds of engagements that could have taken place, many of them were not tried. And the reality is that I think that the OAS needs to have a reckoning, looking backwards in the same way that the UN did on Rwanda and Srebrenica, of how is it that we failed to intervene early in the crisis in Venezuela as it was emerging in 2014. Where do we come up short? What was done and tried, and what wasn't done and not tried, and why were those engagements ultimately unsuccessful to get us to where we are today? I would also just note as well that there is more that can be done within the framework of R2P in Venezuela. One of the things that hasn't happened, and again, I think it also gets to what Diego was mentioning, is for example, both the Permanent Council and the General Assembly of the OAS have adopted resolutions on the situation in Venezuela on very narrow votes, but have done a series of resolutions there. But never once did any of those resolutions, for example, have an operative clause in it that said requests the UN Secretary General to, within the framework of R2P, work to stop the mass atrocities in Venezuela, including by appointing a humanitarian coordinator to deal with the crisis, traveling to Venezuela to try to engage all parties, to bring the mass atrocities to an end, etc. Right, and there is a complementarity between the UN system and the OAS system, and the fact that I think Secretary General Almagro himself has been calling for the UN to do more when it's done very little, except on a kind of individual humanitarian agency basis level. Is something that can be more easily ignored than if it was the Permanent Council of the OAS, for example, that were to request Secretary General Guterres to engage on these issues. And so, anyway, I think there's a lot more that can be done. My work undoubtedly is going to be a work in progress, and feeling through ongoing consultations, what's reasonable and appropriate to be done, and it's exciting work to be involved with, and important work, and undoubtedly I think we all want to undoubtedly, I'm sure all of us want to do a better job in the Americas in preventing and responding to mass atrocity crimes, and so we just need to figure out what's going to be the most effective and appropriate way to do that, and I do think that more does need to be done, because when you look backwards at what happened in Venezuela, you could not suggest, I don't think anyone can objectively say we've done a great job within the OAS at handling the situation in Venezuela and preventing the enormous suffering that is continuing to take place there. And the fact that we failed collectively is an important moment for reflection and for consideration of how do we stop the next Venezuela before it happens again.
Well, thank you, Jared, and it's also promising to hear that the kind of consultation process is ongoing, and we plenty of opportunities for people and organizations across the region, presumably to feed into to that work in progress. So thanks for that, Jared. Viviana, please.
I do believe that the OAS has a role that it can fruitfully play in promoting peace, security, and human rights that is distinct from what the Inter-American Commission and the Inter-American Court can make. I think that issues of fairness and even-handedness and emphasis on the different aspects of building peace and security should be borne in mind. I think some issues have to do with accountability, and I think those issues are best handled by the Inter-American Commission and the Inter-American Court, and I'm going to go into that later. But there are issues on equality and democracy and early warnings where the OAS could do a lot and is not doing a lot. And it could really strengthen the ability of the OAS itself to put forward a much more robust agenda, even with the infrastructure and the limited resources that it has. For example, deploying its national offices to do more work and to do work that is meaningful and is complementary on issues of equality and democracy and early warning throughout the region. On issues of accountability and responsibility, I think, Jared, I've been teaching human rights, and I've also had the possibility and the luxury of teaching prevention on crimes against humanity and genocide as well. With Professor Robert Goldman, and I've been litigating before the Inter-American Court for over 25 years. Yeah. So I can tell you with authority that yes, the Inter-American Commission and the Inter-American Court have talked and intervened in issues of genocide and have called genocide and crimes against humanity many situations, individual and massive situations. So I'm not really sure who did you talk to at the Inter-American Commission, but just a consultation of the jurisprudence will bring you to the systematic work of the Inter-American Commission and the Inter-American Court in addressing these issues, because this has been at the heart of the work of the Commission and the Court since its inception. And unlike what happens in other regions where courts that talk about state responsibility are not very much involved in dismantling impunity, the Inter-American Commission and the Inter-American Court have actually promoted a lot of accountability. I've done research with the Max Planck Institute, and I know a lot of the research that has been done by other scholars like Alexandra Junios, for example, that have talked about how the Inter-American Court has actually helped pursue justice in the Americas, and we have compared levels of accountability for gross violations in different countries in the Americas through the intervention of the Inter-American Commission and the Inter-American Court. And you can see the fingerprints, I don't know, like of the Inter-American system in triggering all of those processes. I mean, starting with the exemplary cases of Cantuta and Barrios Altos, for example. So I think on issues of accountability, on crimes against humanity and on genocide, not only there's a lot that has been done, but the Commission and the Court continue to do. For example, the whole deployment of these GA expert groups, as the one in Ayotzinapa, has de facto expanded part of the tools of the Inter-American Commission to do and cooperate with the prosecutors' offices and with criminal investigations of crimes against humanity.
Thank you for that, Viviana. Over to Diego, and then we'll bring it to a close, I think.
Thank you, Par. I'm going to be very brief, in this discussion. I completely agree, that there's a lot of space to do complementary work to build on what has been built in the Inter-American system. And one of the main actors, again, is the Inter-American Commission on Human Rights. Beyond that, there's space to explore other things that are not being done, even in the Inter-American system, without even calling the UN system to intervene from the political organs. I think there's a very important aspect, which is the mobilization of humanitarian assistance for victims, for example. That may be something that, for example, for an organ like the Commission, it's a bit beyond what they can do. It requires resources, mobilization of political will by the states of the Americas to provide a lot of the humanitarian assistance needed. And it has been mentioned, the situation in Venezuela, we are talking about millions of displaced, internationally displaced persons, refugees, that require extensive, massive resources for their attention. And it's something that I think has not been yet fully done by the states of the Americas. So that's something that belongs, I think, to the political realm of conversation, and that would be very important to facilitate. And this is one of the aspects, core aspects, of course, of the so-called responsibility to protect, the victims themselves. And this is something that could be thought of in the future. The second thing that I believe is strong is the consultation process. I remember a few years ago in Lima, in Peru, there was a process of consultation between the Inter-American Commission. There were actors from civil society talking about what could be done to the future. It was a moment of change of composition of the Inter-American Commission at that point. And I remember that we were there. There were local NGOs, international NGOs, commissioners. And one of the proposals that was made, then I did it with a colleague, was precisely to create some type of a mechanism in that commission that will involve external experts beyond the commissioners themselves to develop work that could take different shapes. A few years later, maybe even months later, the first effort was done precisely with the Ayotzinapa mechanism, which again responds to a consultation process that is extremely valuable. It creates a lot of synergies. It creates a lot of positive political capital, the stakeholders discussing what else to do, talking about experiences in the hemisphere, beyond the hemisphere, what's happening in Africa, in Asia, etc., what is being done. This is something that I think is very positive because it creates a space and it builds a constituency that will support those efforts in the OAS regarding this very important issue. So simply, I will finalize in a call for these important spaces, consultation, I think, involving civil society, academia, both local and international, I think is extremely important and can be very constructive. And again, to thank you all for this very valuable space of conversation, and look forward to continue with this extremely important issue in the future.
Well, thank you, Diego, and thank you to all panelists. It's going to be a huge chance to kind of break this down into different kind of components. But I think what's come across very, very clearly in the discussion here now is the very fact that when we talk about the OAS system, the Inter-American Human Rights System, we talk about a regional system that is incredibly dynamic, has a long history, and that history matters, right? We talked about it in terms of understandings of what intervention may mean, understandings of the type of guiding principles and norms that have shaped kind of cooperation around the promotion of human rights, democracy, peace, and justice, if I may, for many centuries, right? In effect, you know. So a sense of history is important, but we also have a sense here that there are a whole range of different perspectives on the region as to what could be done and what should be done in response to many challenges that are, of course, very, very real, whether we talk about climate emergency or indeed accountability for gross human rights violations or crimes against humanity as they are occurring. So I think we could thank all the different kind of panelists, and I'm not sure if Frederick or perhaps even Ulrika would like to add something for the final moment or so. No. Shall we bring it to a close?
I can perhaps just add very quickly, Per, apart from adding my sincere thanks to all of you. It's been amazingly interesting. And just to say that as we speak, the Swedish government is also preparing a new cooperation strategy, a regional one for Latin America, which we are eagerly awaiting. And that will be very interesting to see what approach they take. And I think that we will really try and make them be one of the, well, part of the audience for this interesting session, which will be obviously recorded for the Human Rights Days, and also we will put it out on YouTube at a later stage. So many thanks.